Hi, Bob Kerrigan for Kerrigan Estess Rankin McLeod and Thompson. You know, lawyers talk about slip and fall cases, and sometimes people hear that kind of conversation or read about an article about someone who slipped and fell and brought a lawsuit. And so people conclude sometimes, well, if you slip and fall on somebody's property, they're legally liable to you for the damages that you have sustained if you broke your leg or your arm or sustained a serious injury. Well, it may or may not be true, so I'm going to read to you the law in Florida very briefly and then talk for just a second about slip and fall cases. If a person slips and falls on a transitory foreign substance in a business establishment, the injured person must prove that the business establishment had actual or constructive knowledge of the dangerous condition and should have taken action to remedy it. Now, this is talking about a transitory foreign object. That means something that isn't affixed to the premises. Let me give you an example of something that would be affixed to the premises. Pardon me. Something affixed to the premises would be, for example, a sharp metal object that was part of the molding or framing of a door or was protruding in such a way that it caught a person and cut their leg or, in fact, caused them to trip and fall. That's not a transitory object. That would be a question of ordinary negligence. Is this what a reasonable person should have seen and corrected on the premises? So what does it mean when a transitory object, and that could be water, it could be a banana peel, or anything that is movable and not part of the premises, what does it mean to hold the business owner liable? It means that they knew or should have known that the condition existed. How do we test that? Part A of the statute says the dangerous condition existed for such a length of time that in the exercise of ordinary care, the business establishment should have known of the condition, or the condition occurred with regularity and was therefore foreseeable. Meaning that every time it rained, if a large puddle of water accumulated right at the front door of, say, a store, and they knew it when it rained, and they didn't do anything about it after it rained, and rain's been over for 2 or 3 hours, and they know that water's puddling up in a way that people might not see it and slip and fall, then they're responsible for it if they knew of a condition that was recurring. Now, let's take an example in a food store. You go down the aisle in the food store, and the person ahead of you in a cart bumped a can of something or a bottle of something, and it spilled on the floor, but it was just in front of you. And say it was normally stacked in a proper way on the shelf, and the shopping cart hit it, and it spilled, and you came along after that and slipped and fell. There was an adequate time normally for the store to have addressed that because it just happened. So a store is not responsible for that if they didn't contribute to it. Now you might say, well, what about the fact that the store put this liquidy substance, soapy substance, on the bottom shelf and knew that their carts could strike the bottom shelf in a way that would dislodge something and cause it? Well, they might be liable then on a different theory. That is, that they stacked the merchandise in the store in a way in which it could be easily spilled, and therefore the substance on the floor could cause someone to slip and fall. Like all legal cases, though, you can't say a hard and fast rule that because you fell, someone is legally liable, nor can you say, as a store might say, we're not responsible, you should have looked where you were going. But finally, in Florida, as we discussed in our video on comparative negligence or comparative fault, if you go into a store with flip-flops on and you're not looking where you're walking and you're talking on your cell phone or texting and you slip and fall, then you may be precluded from recovery. A jury may say you're all at fault, or the jury might say you're 75% at fault, the store's 25% at fault, therefore your recovery is 25% of the total. Slip and fall cases require a level of expertise in the handling of those cases by a lawyer who has certainly tried many of them and talked to many clients or prospective clients who've had this happen to them. In our firm, it's Randy Thompson, knows more about this than anybody else. So if you have a question about a slip and fall type accident, you can call Randy. There's no charge for him to consult with you and no obligation at all for you to hire him. Kerrigan Estess Rankin McLeod and Thompson, we are board certified experts and specialists in accidental injury and death claims.